Right, recording in progress. Here we go. So, good afternoon, everybody. It is so good to be with you and see your smiling faces. I miss you dearly, and I hope you're all doing well and staying safe. We're talking today about the Constitution in the time of coronavirus and COVID-19. My name is Steve Schwinn. I teach at the John Marshall Law School, UIC, John Marshall Law School, and I teach constitutional law. I'm really excited about this program today. I want to thank the dean for getting us going on this. I want to thank Michael and Jody and the tech team, just everybody on the tech team. The IT help desk have just been so tremendous in putting this together, and I really appreciate all your assistance. I just want to give you a kind of a sense of space right now. We're in my house, in a room where we've got a number of different musical stuff going on. And so you may see the piano in the background. I've got a little board here that I'm going to use in a second to write on. And what I'm going to ask you to do is, if you have any trouble at any point seeing anything or hearing anything as we go through this, give me a little hand wave, or I can also keep an eye on comments. So if you want to write me a comment, I can try to keep an eye on those. With 90 people on the line, I'm going to confess it's going to be a little bit difficult to manage the hand waves and the comments, but I'm going to do the very, very best that I can. What I'd really like to do is make this not so much a lecture. I've seen a number of these online, and I got to tell you, they're great right before you go to sleep at night. So I'd like not to do that. What I'd like to do instead is have this as interactive as possible, given the limits of technology. So let's try to do that. And again, what I'm going to do is try to recognize hand waves and call on folks. And if there's anything going on technically, or anything that I'm not doing, or questions, substantive, whatever, write me a little chat and I'll try to keep my eye on that as well. All right, and I've got Michael Huggins in my big screen, which I totally appreciate. So Michael, if I'm screwing something up way too much, can you just give me like a visual thumbs down? Awesome, thanks, man, I appreciate it. Okay, let's get going. So the Constitution in the time of coronavirus, and I just want to show you, I'm all armed here, and I hope you are too, with your copy of the Constitution, right? And who wouldn't be? I mean, we carry this wherever we go, don't we? Of course we do. All right, so let's talk about, Hawkins has his Constitution. This is lovely. All right, so let's go ahead and do some very basic stuff about the Constitution, and then we're going to try to translate some of that into some of the policies that we're seeing and some of the constitutional debates that we're seeing with regard to coronavirus, COVID-19, some of the things the states are doing, the federal government is doing, try to make heads or tails of some of this. So I want to start with very, very basic principles. We remember that constitutional law, we can think about this in a couple of different ways, right? We think about constitutional law as empowering the government, both federal government and the states. In other words, we think about the Constitution as a source of empowerment or authority for the government. And so we study how the power structures of government. We study things like federalism. We study the separation of powers, and I'll give you some constructs for those things here in a second. That's all on the authority side. The other thing we worry about in constitutional law is individual rights, right? Individual rights under the Constitution, in the Bill of Rights, of course, 13th, 14th, 15th Amendments, a number of other amendments to the Constitution, but also in some of the structural provisions in the Constitution, like, remember this, the Privileges and Immunities Clause of Article 4. How about that? I bet you weren't ready for that today, were you? Or restrictions on state authority in Article 1 of the Constitution, or the 10th Amendment, for goodness sake, right? We have a lot of things in our Constitution that deal with structure, but are also designed to protect individual rights. And in truth, all of our structure is designed to protect against individual rights and protect us against tyranny. In a time like this, that's when we see some of these mechanisms pushed to the edge, right? Because we're dealing with an emergency here, a real state of an emergency. And I'll have a little bit more to say about that in just a second. But we're seeing these institutions really pushed to the brink of constitutional law, both in terms of federalism principles and separation of powers principles. And all that makes us really wonder and kind of scratch our head, what's going on with regard to individual rights, right? So that's what we're going to talk about. Now, as it happens at the UIC John Marshall Law School and at many law schools around the country, we divide constitutional law into those two sections. So for those of you taking Con Law 1, you'll recognize what I say about authority, right, as the topic of your course. For those of you taking Con Law 2, like my students this semester, you'll recognize what I say about individual rights as the second part of what we talked about. Let's try to put all those together. So I want to start with powers. Now, what I mentioned is there are two kinds of powers that we worry about: federalism powers, separation of powers. All right, now I'm going to get out. You're going to love this. You ready? Okay, I'm going to get out my Sharpie. I use a Sharpie just like our president does. And you may remember Sharpiegate. That had some, incidentally, Sharpiegate had some really interesting and deep and profound separation of powers problems with it. But I digress. We could talk a lot about that. In any event, I am going to use my Sharpie on my sort of makeshift kind of whiteboard here. My kids let me use their one of their music stands, and I'm using my music stand, so we're kind of all set up here. All right, are we ready to go? Let's do it. So with regard to federalism, we can think about federalism this way. We know the federal government has powers, right? Let's represent those powers with a circle. This we'll call the federal government circle. I'm going to draw really carefully here because my stand is just a little wobbly. Can you see that? I can kind of see it. Okay, good. So we're going to call this federal power. What I wrote by that circle is just Fed, F-E-D, for federal power. Okay, so the federal government has power. It derives principally from Article 1, Section 8 in the Constitution, but also the 13th, 14th, and 15th Amendments, a couple of other places in the Constitution. But that's our federal power. Now, states also have power. We know this, right? States have what we call generalized police power. It's broader power than the federal government in some ways, but it's also more constrained in other ways. And that's where we need to worry about this. But as it turns out, because it's both broader and more constrained, we can represent state power as a circle overlapping our federal circle, right? It's kind of a Venn diagram. Do you remember Venn diagrams from grade school? Well, this is going to take you right back, right? Isn't this fun? Okay. What I'm going to write here is just state authority. And the area where they intersect, well, that's the area where they overlap, where both the federal government and the state government have authority. They have kind of concurrent authority over a number of different topics. We know in this area, whatever that area is, we know that the federal government is supreme, where the federal government law clashes with the state. That's just under the supremacy clause. We know that, right? So if you need a little bit of help kind of wrapping your head around some of this stuff, we can think about the federal power, this unique federal power. Think about things like foreign affairs, right? Foreign affairs or wartime authority. Those are uniquely federal powers. The states don't have anything to do with that. Immigration mostly falls into this area, although states have a little bit of immigration power themselves. As regards to state power, this area that is exclusively state power, that would be the state police power. We typically think about things like education or family law, marriage and divorce, that kind of thing, wills, trusts, estates, property, those kinds of things. Ordinary contracts, right, ordinarily fall under state law. Not that the federal government couldn't touch those things and doesn't, but mostly it keeps its hands off. Mostly those are within the state police power. What else? Well, get this, public health. Public health, exactly the crisis that we're dealing with. Now, in truth, public health is mostly and traditionally has been a state authority exclusively, but it also bleeds into the federal authority. And if you remember your Con Law 1, you'll remember that Congress has power under the Commerce Clause to regulate things that touch on interstate commerce, right? Well, public health touches on interstate commerce. Sure, it does. Congress also has authority under the spending power. Its spending power allows it to spend money and to tax in the general welfare, and public health undoubtedly is in the general welfare. And so we have programs like Medicare or Medicaid, for example, which are federal spending programs designed to promote the general welfare, and in particular designed to promote public health, right? And we have other federal regulations that we'll take a look at here in a second that fall into this public health space. But I think it's fair to say, while public health mostly is a state responsibility in our system, the federal government also touches on it. So let's write this kind of like this. We'll write public health. Now, what this helps us sort out is when the federal government is taking action, like quarantining action, for example, which, by the way, the federal government has not yet done, but we'll talk about federal authority to do that. When the federal government does that, it's operating in this joint space with the states, because the states can also order quarantines and isolations, as we know quite well here in Illinois. We'll talk about that in just a second as well. But when the federal government does it, if it wants to trump, let's just for kicks, right? If the federal government wants to trump state law on isolation and quarantine, it can. Why? Well, again, because of the supremacy clause in our Constitution. So that's the general federal structure, federalism structure that we have, where public health kind of bleeds between the federal government and the states, but traditionally, historically, has mostly been up to the states. Now, let's talk about separation of powers for a second. You want to? I think, see how we can do this. I think what I'm going to do is just flip this one right around. What do you think of that? Does that work for you? Yeah? Okay. So in separation of powers, we actually have the exact same two overlapping circles, but they're different circles. And so let's tease that out. More Venn diagram, more fun for us, right? Okay, so we have two overlapping circles here. We're going to represent the separation of powers here between the executive branch, the president, and Congress. The Article 1 branch, Congress. I'm writing Congress here. You may not be able to see it. It's kind of small. And I know that this isn't coming through great on your board. Now, these powers overlap as well, just like federal and state authority overlap. And what that tells us is that the president has some uniquely presidential powers that belong only to the president. You might be wondering, well, what are you talking about? For example, the commander-in-chief authority is a classic example of power that belongs only to the president, right? The power to recognize foreign countries. The power to recognize foreign countries and engage in foreign relations is shared between the president and Congress, but falls largely on the presidential side. On the congressional side, Congress has some authorities as well that belong uniquely and only to Congress. So, for example, Congress can raise and support armies, right? Congress can raise and support armies, but then the president operates as commander-in-chief. So much of their area is overlapping, though. So much of their area is overlapping. And so when we're working out who has authority to do what, and you might be asking questions like, does the president have power to do such and such? Well, what you want to ask yourself is, does the president have statutory authority from Congress to do it? And if so, what we say is the president is at the apex of presidential authority. Or does the president have unilateral presidential Article 2 powers under Article 2 to do something? Now, in the current crisis, the president probably doesn't have any inherent Article 2 powers to do anything in this particular crisis, with maybe just one caveat. We'll talk about that in a second. And the reason why is because, again, so much of the uniquely Article 2 presidential powers fall in the area of things like foreign relations or commander-in-chief. And we're not really talking about foreign relations or commander-in-chief authority. when we're talking about dealing with the coronavirus or COVID-19. So what we want to look to is whether Congress has empowered the president to do such and such. Let me give you an example. So in recent days, we've been hearing a lot from the White House and other sort of news sources, I guess, and opinion makers. We've been hearing the question, can the president order isolation or can the president order quarantine? Well, the answer is maybe. Maybe. Can the president do it as a uniquely Article 2 power? Probably not. Probably not. Can the president do it if the president is authorized by Congress? Yes, the president could probably do that. Now, that would then in turn on the question whether Congress has the authority to do that kind of thing in the first place. And Congress may have some authority. We'll explore that here in just a second, drawn mostly from the Interstate Commerce Clause, which I had mentioned a second ago. The framework that I have on the board, by the way, is just a graphic version of Justice Jackson's famous concurrence in the Youngstown Sheet and Steel case, the Truman era case where Truman tried to take over industries without statutory authority. We'll talk about how that works today. Okay, so I'm going to just give a quick check here, make sure we're flying along okay. I'm kind of getting sick of hearing myself talk, so we're going to try to move through a couple of issues that I wanted to hit on and then see if we can do some questions. This, by the way, I swear to you, this is coffee. It's not beer. Honestly, it is. I love to drink a lot of coffee, and that's my big coffee mug here at home. So that's what it is. Okay, so we've got this. Now, there are a couple of issues that have come up that sort of repeatedly come up that we need to talk about. And many of them involve rights. So let me just say a quick beat about individual rights in our constitutional system, having talked about some of the power structures in our Constitution. We're hearing a lot these days about individual rights and whether individual rights provide a kind of backstop to government authority when government's trying to do such and such, whatever it's trying to do, in response to coronavirus. We hear claims about due process, we hear claims about equal protection, we hear claims, or we ought to hear claims about the right to travel. We hear claims about things like property rights, right? And even free speech rights. Here's an interesting thing we'll talk about in just a second with regard to free speech. We in our constitutional system, I thought this might be kind of interesting for you if we just took a beat on this. We in our constitutional system, we recognize that rights are not absolute, right? And so in Con Law 2, we learn about all the rules and regulations about rights, the limits of rights, how we exercise rights, and the, sort of what they mean. And what we know, for example, is that free speech doesn't mean that we have an absolute right to free speech and to say anything that we want, anytime we want. What it means is a kind of qualified right. And we sort of build that into our understanding of the First Amendment through a series of Supreme Court cases that have interpreted free speech. Well, that's not true in a lot of other countries. So in a lot of other countries, what they have in their very constitution is an emergency clause that allows the government a little bit more, let's call it wiggle room, with regard to exercising policy that might otherwise infringe upon rights during an emergency. Exactly the kind of thing that we're dealing with. So let me give you an example here. I not only have our Constitution on hand, but I have this one with me as well, the Constitution of South Africa. And I'm going to turn to a section here called States of Emergency. It's pretty typical in modern democratic constitutions. A state of emergency may be declared only in terms of an act of parliament, and then it tells when an act of parliament may do that. It goes on to say that during a state of emergency, certain rights, and it actually has a really kind of awesome chart right in the Constitution, that certain rights are derogable, that is, that government can infringe certain rights in a national crisis, and other rights are non-derogable. That means that government can't infringe on those rights even in an emergency. That's kind of an interesting constitutional way to deal with the problem. It turns out we don't do that. We don't have an emergency clause in our Constitution, but emergency powers kind of operate maybe in a similar way. What I mean by that is when claims of right go before the courts in times of emergency, what we see is the courts, time and time again, the courts give deference to the what we call the democratic branches of government, whether Congress or the president or state legislatures, in dealing with a problem. Part of that is just practical, right? Judges don't want to be on the hook for issuing a ruling that's going to stand in front of public policy and prevent the government from doing what it needs to do to address a crisis like this. And part of it is based on practice and precedent in our history and tradition, that the courts have just kind of always done that, and so they kind of always will. When we're in a crisis, we do kind of have an emergency clause in our Constitution, but it doesn't operate in exactly the same way that other modern democracies do. Now, having said that, we do obviously have one emergency clause, the habeas clause in our Constitution, but and it contains its own provision for when Congress can say no more habeas corpus. It may be relevant in the current debates when we're under quarantine and isolation. One thing that we can always count on is habeas corpus. All right, let's talk about some issues and kind of go through some of these, and then we'll see if we can take some questions. We doing okay, everybody? Awesome. Thank you, thank you, thank you. Okay, so first and foremost, quarantine and isolation orders. Let me just talk about what's going on here in Illinois first, and then we'll kind of expand that and think about what can happen outside of Illinois with the federal government and other states. So in Illinois, there are two sources of authority for quarantine and isolation orders. Think about them as one, a kind of ordinary authority for quarantine and isolation orders that's built into the Illinois State Code for the Illinois Department of Health. Number two, emergency powers that belong to the governor. All right, let's take those one at a time. With regard to the ordinary powers under Illinois law, the Department of Health can order quarantine and isolation if there's a need for it, basically. The statute books allow for that, and then it allows for some due process for individuals that are under quarantine and isolation orders, so that they get things like routine checks, they get opportunities to challenge the quarantine or isolation order, and other forms of due process that you might imagine if somebody is under a ordinary, let's call it ordinary, here air quotes, ordinary quarantine or isolation order. Obviously, there's nothing ordinary about that, but I'm calling it ordinary shorthand because that's hardwired into our statute books, and it's something that the Department of Health can do when it needs to. The second kind of authority is emergency authority that the Illinois State Legislature has given by statute to our governor to operate during a time of emergency or crisis. And that's the authority that Governor Pritzker has used to issue this series of executive orders now to order isolation and quarantine. It hasn't been the ordinary authority. It's not that first kind. It's the second kind, the emergency authority that Governor Pritzker has, again by statute, to order the isolation and quarantine. Now, this is going to give Governor Pritzker a little bit more flexibility than the Department of Health would have under its ordinary quarantine and isolation authority. Why? Well, because we're in a time of emergency, and Governor Pritzker can, by statute, basically make it up as he goes. And what I mean by that is tailor the policy response to the evolving nature of the crisis. I don't mean make it up like throw spaghetti on the wall. What I mean is actually come up with a tailored response, and you can kind of see this evolving through the series of executive orders that the governor has issued, a tailored response to the crisis that we're facing. So I just want to be clear about that. The reason that, for example, we in isolation or quarantine right now, even if the governor were to order it, and even if there were, say, police officers on the street enforcing it, the reason why we don't have the same kind of due process rights that we would have in an ordinary quarantine situation is because we're not under ordinary quarantine. or under these emergency powers by the executive. Okay, so can states do this? That's a really good question. Yeah, states can do this. And here's the thing that, that you may not know. We've done this for a long, long time. Back to our colonial period, as a public health measure, states and, well, then colonies, I guess, were using quarantines on a regular basis to address public health crises, just like we are today, only doing it in a lot more aggressive ways. Under our early constitutionalism, same answer. The states have been doing this. And at every point during our history, dealing with everything from yellow fever to typhoid to all kinds of different public health crises, the flu pandemic in 1918 to 1919, the state governments have been using their power of quarantine and isolation as an ordinary police power. Remember on our Venn diagram, an ordinary police power to order people to stay in place. If you have a problem with this on the right side, what do you have? Well, I suppose at some point you may have something like a due process claim or possibly an equal protection claim, depending on how the isolation order is tailored. Let me give you an example. So in the early 1900s, the city of San Francisco and the state of Hawaii had the bright idea to order quarantine for Chinese citizens who were living in those locations only. And what they were trying to do is fight plague. And the case never got to the Supreme Court, but the lower court said, no, you can't do that. You can't just shut down one population like the population of Chinese in these locations. It doesn't make any sense. In other words, the solution doesn't fit the problem. Right? The problem is not only in the Chinese community in those locations, it's also in the community, the broader community, the wider community. And so if the government's going to order isolation or quarantine, it's actually got to fit the nature of the problem that it's addressing. If it doesn't fit, you may have a constitutional problem in the spirit of due process or equal protection or something like that. And remember, we always have habeas corpus, right? So if we were under strict quarantine and the government officers were really at our door keeping us in our house, we probably would have a right to habeas corpus. Just kind of keeping my eye on the chat. Jennifer Pope, you are awesome for posting that. I totally appreciate that. Thank you. And I hope everybody can see that. If you can't participate by voice, you can ask a question here in chat. And again, I'm going to do my best to keep an eye on all of these things. Hey, and just while I'm glancing at this, what an awesome community we belong to. We have 101 people taking their time on a Thursday at noon to do this. I am so proud of this community. Oh wow, this is awesome. Thanks everybody. Oh, 102, even as I said that, we went to 102. Okay, so what about the federal government's authority to quarantine or isolation? Well, this is a little more complicated. The federal government, under Article 1, Section 8, Congress has power of interstate commerce, and it can use its interstate commerce power to regulate things even purely intrastate, even within one state, so long as it has a substantial effect on the interstate economy. Now, Congress has enacted some legislation to this end that has to do with quarantine and isolation, and delegated authority to the Centers for Disease Control to enforce and order quarantine and isolation in some circumstances. But I gotta say, Congress has been really, let's say, small c conservative about this. And what I mean by that is it's allowed the CDC to issue isolation and quarantine orders with regard to foreign travel into the United States. Now that's easy, Foreign Commerce Clause, right? And it's allowed them to issue quarantine and isolation orders to restrict travel across state lines. Again, easy. That's interstate commerce, or at least it directly touches on interstate commerce. Congress hasn't, in plain terms, authorized the CDC to order quarantine or isolation, purely intrastate, purely within a state. Although some people have read the statute, and I think there may be good reason to read it this way, to say that the CDC does have that power. It doesn't obviously have that power under the statute as much as it has the power to regulate international travel into the United States or travel between states within the United States. The statute here, by the way, is called the Public Health Service Act. And if you want to drop me a note or email at some point, I would be more than thrilled to cite chapter and verse, but I'm not going to bore you with that now. So the CDC has authority to do this. Interesting question. Does the president have authority to do this? Now, we're not talking about federalism. We're talking about separation of powers. Whoa. That's a whoa moment. Separation of powers. So the Congress has authorized the CDC. The CDC is under the authority of the Article 2 branch, under the authority of the president. So you'd think that power could kind of flow up to the president, and the president could exercise the CDC's power, or the president could order the head of the CDC to issue an isolation or quarantine order that would operate purely intrastate. Yeah, maybe. Some people have floated that kind of theory. Other people say, no, not so much. When Congress delegates authority to an executive officer, that authority goes to the executive officer, not to the president. The answer to this, well, we don't really have an answer, but there are a couple of theories out there. The unitary executive theory leans toward the idea that the president would have plenary authority over what goes on in the executive branch. But again, others say if Congress is delegating authority to the Congress, after all, created, the head of the CDC, then that authority only goes to the head of the CDC and the president can't exercise it. So answer, as like so much in law school, we don't know. If the president were to issue this kind of order right now, what would happen? Well, it would be litigated, undoubtedly. And the courts, I think, would probably defer to the president. But I got to say, this president, and I don't want to beat up on Trump, but I'm going to say this president, like other presidents, is uniquely good at putting issues out there and then running the clock through litigation. Again, other presidents have done that as well, but this president has developed a real skill at that. So if President Trump were to do this now, he could probably run the clock through the litigation and affect the policy, even though it might not, strictly speaking, be legal. But if the president wanted to make it perfectly legal, here's the thing to do. Just wander down Pennsylvania Avenue, ask Congress for the statutory authority to do it, and then go ahead and do it. At that point, the president clearly has authority to execute the federal law. The more interesting question at that point would be, did Congress have the authority to enact it in the first place? In other words, is isolation and quarantine stuck in our homes, is that something that touches on interstate commerce? I would think, given the current situation and what we're seeing with this, I think a lot of people would say yes, which is kind of interesting, right? We're seeing with public health through the coronavirus crisis, what we're seeing is, again, really kind of testing the limits of our institutional structures. And here, testing the limits of our understanding of Article 1, Section 8, the Commerce Clause. What is interstate commerce? Well, we're discovering more and more through the coronavirus that even things like staying home or not, right, could reasonably touch on interstate commerce. Now, we might not have said that 6 months ago. And in fact, a good number of folks wouldn't say that even today. But we're seeing more and more evidence of that. So our understanding of what interstate commerce means is kind of evolving. We don't even need to go that far, though. The whole reason why we created a federal government with the kind of authority that it has in Article 1, Section 8 in 1787, oh, I get weepy even when I say that. The whole reason why we did that is because states were running amok under the Articles of Confederation, and we needed a unifying federal force to bring them in line when there were collective action problems of exactly the type we're dealing with today. So does Congress have authority to do this? I would say almost surely it does, to order even purely intrastate quarantine and isolation under the Interstate Commerce Clause. And if Congress were to do that, then the president can enforce it. All right, let's talk about a couple of other things. Doing okay, doing okay. Oh, you're the best. You are all the best. Yeah, okay, good. Great question, Claire Cunningham. I love it. If the president issued an order that conflicted with the governor's stay-at-home order, which authority would rule? Well, let's first assume that they conflict, okay? And well, your question says that, I'm sorry. So yeah, okay, they conflict. The answer to the question is, if the president had authority to do it, that is, if the president's drawing on congressionally delegated authority to do that and validly executing the order, then the president's order would prevail over the state law order. And that is supremacy clause. Okay, good, good, good. So there's an earlier question from Sean Cash, and somebody just reminded me of it. Thank you. This is fantastic. And this leads right into the next point I wanted to talk about. What if a state, I don't know, like Texas, for example, or Florida, what if a state wanted to restrict immigration into the state from citizens of other states, right? So if Florida, for example, said, we don't want people from New York or Connecticut or New Jersey to come into our state because those are high impact areas and we're afraid that they're going to infect our population, what do we do? Let's work that out. So first question, can states do it? Well, it's probably part of their police power to restrict or to allow travel to some degree, at least purely intrastate. But on the right side, you got a couple of problems. First off, you got a problem with a state like Florida treating citizens of other states differently than Florida citizens, right? Now, if you studied the Privileges and Immunities Clause in Article 4, you know what I described as a big no-no under that clause. Florida can't do that. No way can they do that. The other thing that might trouble you is Florida's interfering with the right to travel, right? And whenever a state interferes with the fundamental right to travel, that interference is going to be subject to strict scrutiny, the highest level test known to constitutional law. Now, would Florida have a compelling government interest in doing this? Yeah, probably. Public health and safety is probably a compelling government interest. But is this the most narrowly tailored way to achieve that end? Probably not. So if you're listening, Florida legislature, let me give you a suggestion. Don't just ban immigration from New York citizens. Ban immigration from anybody who's been to New York, right? Including your own Florida residents. That way, you get around the Privileges and Immunities Clause problem because you're not labeling people by state. Instead, you're labeling people by connection with a state, having been to a dangerous area. That's not a problem. You're treating all citizens alike. The question is, have they been to a dangerous area? You're also better dealing with the right to travel problem. You're making your policy more narrowly tailored to deal with the problem, because really what you want is to keep out people who have been at heavily infected areas. You don't want to keep out just New Yorkers. You want to keep out anybody who's been to a heavily infected area. So yeah, these are problems under our Constitution. Whether we'll see them litigated and how the courts will go, I think is kind of all subject, sort of all up in the air at this point, because so much of this is new, we don't really know. But I've just given you my prediction, and I've also given you a policy prescription to get around this. It's not a hard thing to do at all. Just treat everybody the same. Jenny Armstrong, I love you, and I love your question. This is awesome. So let's do this. And this goes right to my next point too, or a similar point. How do stay-at-home orders affect religion? What a good question. Okay. Here you've got public policy running up against religious freedom, right? And we've seen examples of this now in Louisiana, in Florida, with pastors of megachurches encouraging their congregation to come to church, even though the states are under stay-at-home orders or isolation recommendations. And in some instances, we've seen the state authorities actually go in and try to enforce against religious leaders. I mean, this is really uncomfortable in our tradition, right? Because you've got a public health crisis, but we also have a really strong streak in our tradition of open religious liberty. We call that free exercise under the Free Exercise Clause of the First Amendment. So let's work it out. If you know about the Free Exercise Clause from Con Law 2, and for my own students, you will soon enough, the Free Exercise Clause allows free exercise of religion. And what it says is whenever the state goes around beating up on a religion or a religious practice overtly, that state policy will be subject to strict scrutiny and it will almost surely fail. But whenever a state law is neutral with regard to religion and broadly applicable to a wide swath of people, religious and non-religious alike, but has an incidental effect on religion, that law is going to be subject to mere rational basis review and almost surely upheld under our Constitution. So let's sort this out. What we have is a broadly applicable law, stay at home. Everybody has to stay at home, right? It doesn't target religion in particular. It means everybody has to stay at home. Religions can't congregate, but neither can non-religions. Neither can my book club, neither can, what have you, my basketball team, whatever it is. They can't congregate either, right? And so you've got a neutral law of general applicability that has this incidental, we'll put in air quotes because it's a significant intrusion on religion, right? But the point is it's an intrusion on everybody else as well. What the court calls an incidental effect on a religious practice. You can't get together in your megachurch. And it'll be subject to rational basis review, almost surely upheld, which means as uncomfortable as this is in our tradition, state authorities actually can go in and enforce those orders against religious practitioners. How about that, right? Am I right? Let's see, your questions are way better than my topics, except what I want to do is talk about a couple of things that are on my list. Actually, three more things. So number one, this is, right? And that means that they're also closing down abortion providers. Is that a problem? There are some lawsuits now working their way through the courts. And so far, what the courts have said is state stay-at-home orders and business close-down orders, to the extent that they prevent a woman from exercising a fundamental right to abortion. And remember, Roe v. Wade is still good law as modified by Casey. It's the undue burden test today. But states have to allow a woman to exercise her right to an abortion, even when they're ordering businesses closed, say the courts so far. But again, so much of this is up in the air. We'll have to see what the courts say as we kind of move forward. Similar question with regard to gun stores, right? Are gun store shutdowns, along with shutdowns of every other business in a state? Now, incidentally, in Illinois, we've exempted gun stores, but in some states they haven't. And we're starting to see litigation. The claim here is that the store shutdown, as it affects gun stores, interferes with Second Amendment rights. What are the courts going to do? Who knows? I really don't know. My prediction is that they would likely uphold the state shutdown order. Now, complicating this is an over-the-weekend White House interpretation handed out to the states that says gun retailers and manufacturers are essential businesses. But the order was also careful to say it's only advisory. The federal government is still deferring to the states on these questions. So we'll see this litigation continue. We'll follow it closely. I'll follow it on the Con Law Prof blog for those of you that read my stuff on the Con Law Prof blog, and we can kind of see how this works itself out. Final thing, what about so-called death lists that we're starting to hear so much about? Are there restrictions on states' ability to prioritize access to medical services by characteristics, right? Yeah, of course there are, right? This is standard equal protection stuff. States can't discriminate by race, they can't discriminate by sex at an intermediate scrutiny level, but could they make decisions based on state of health, for example, right? Or could they make decisions based on whether you have young children at home or not, for example? Yeah, sure, they probably could make those kinds of resource decisions. Again, as uncomfortable as that kind of thing is in our system and tradition, those kinds of decisions would almost surely pass equal protection scrutiny. And oh, Huggins, you're the best. Thanks, man. Um, and stand up to that kind of scrutiny. All right, I'm going to shut up here for a second. I'm talking way too much. Let me just see if there are questions. You know what? That's kind of hard for me to do. Does anybody have a question you want to ask to us audio? Could you raise your hand if you do? I'd love to hear you. Sean Cash, is your hand up? Put your hand down if it's up. Okay, awesome. I'm going to unmute you here, Sean. Let's hear your question. Go for it.
Well, I actually didn't have a question. It was on for a while. I didn't notice.
Oh, about that. Okay. Timothy, I'm not sure which Timothy we are, but Timothy, I'm going to unmute you here for a second, okay? Timothy, did you have a question, or is that an accidental hand raise? Okay, we're going to go back on mute. Let's see. I think I heard somebody. Rachel Klein. All right, I'm going to unmute you, Rachel. Here we go. Oops. Okay, unmuted. Go for it.
Hi, can you hear me?
I can hear you. Yes, it's so good to hear your voice.
Thank you. So I know that I'm not sure if HIPAA is federally regulated or state regulated, but I know that in other countries such as South Korea, they're really effective in controlling the spread of virus by sending out text messages to individuals when they were in contact with someone that was affected. Yeah, and I know it's an issue here with HIPAA violations. I know in the state of Michigan, our Attorney General was able to suspend parts of HIPAA, allowing that first responders would know that the person was infected when they're going to pick them up. Yeah. Would the president be able to do that on a national level? Or like, would he be able to do it if Congress empowered him to do that, or are there other issues?
Yeah, fantastic questions. Really, really nice. I'm going to go ahead and mute you again. Yeah. Okay. So HIPAA is a federal law and enacted under Congress's Article 1, Section 8 powers the Commerce Clause, and it provides a universal nationwide kind of privacy protection with regard to medical records. How does all that play with regard to things like revealing who has coronavirus or COVID-19, where they live, where their phones are traveling, for example, that kind of thing? Well, I'm not an expert in HIPAA privacy law, so let me just start there. But it wouldn't surprise me at all if HIPAA had some kind of contingent plan for this kind of thing, or at least some language that could be read to give some flexibility in invading what would otherwise be privacy in a public health kind of circumstance. Okay, now somebody who's an expert in public health can weigh in and tell me I've got that all mucked up, I totally messed it, and I'll happily accept your criticism. Let me tell you what I am expert about. Could Congress enact a law that would authorize the president to relax privacy rights under HIPAA in order to address the coronavirus? The answer is almost surely yes. Congress would have authority under Article 1, Section 8, the Commerce Clause, in order to do that, because again, we're recognizing more and more that where we identify individuals with COVID-19 has a substantial effect on the interstate economy, even if those individuals are purely in their house, right? I mean, that's the whole point to home isolation. And so could Congress enact the legislation? Yeah, almost surely it could. And if it could, then the president could enforce it. So yes, there is a role for the federal government in relaxing privacy protections in order to deal with a crisis like this? That was an awesome question. I totally appreciate it. Good. Thank you for that link for more. Oh, this is such a team effort. I love this, everybody. Okay, so I'm kind of scrolling through, seeing if there are any more hands. We got a couple of more minutes for questions. LaShawn, LaShawna went down. Keisha, I see your hand. I'm going to unmute you. Okay, Keisha, go for it. Keisha, all right, I'm going to mute you back up here. I'm going to jump to LaShawna, who put her hand up. Hey, LaShawna.
Hi, Professor. Can you hear me?
How are you? I hope you're safe.
I am. I'm trying my best. Thank you. And thanks for doing this. This is awesome.
Oh my gosh, this is such a thrill for me, and I so appreciate you participating. It's so good to hear your voice.
Thank you. My question is, I'd like your thoughts on hospitals possibly implementing DNRs for COVID patients.
Without, I take it without their previous signature.
Yes. I've heard that, or I've read that there some hospitals, especially in New York, are doing it even if they, want it to be resuscitated.
Oh, that's going to be a problem. Okay, so I'm going to put you back on mute just so that we don't have any accidents here. Okay, that's a great question. So LaShawna's asking about hospital-enforced DNRs, do not resuscitates, when a patient either doesn't want it, right? That would be the extreme case, or when a patient hasn't indicated their consent. That's a really good question. I'm going to give you my best thoughts on that, but these are just Steve Schwinn's best thoughts. So first off, to the extent that hospitals are doing this kind of thing without a patient's permission or in direct violation of a patient's wishes, you might, on the face of it, have some sort of state law, even state criminal law kind of action on the part of the hospital. Unless the hospital is a public hospital, you probably don't have any constitutional problems because you need a state actor for constitutional problems, but you may have some state or even federal statutory claim against the hospital. But here's the thing. Hospitals are in a position more and more where they have to allocate resources by characteristics, as we talked about earlier. And so when these cases, if these cases proceed on to the courts, how are the courts going to deal with that? I think that's going to be a really hard question for the courts. What they're going to have to do is balance the government's interest in or the hospital's interest in balancing resources and providing resources to as many people as possible versus taking pretty dramatic action that under ordinary circumstances would, I think it's pretty safe to say would be flatly illegal. That's going to be a real hard one, and I don't have a great answer to the question. What I can say is unless the hospital is a government hospital or has some real close connection to the government, you probably don't have any constitutional issues with that, but you very well may have statutory and state criminal law issues with it. That was a really good question. You got me. Good one. Holly, I see your hand is up and you may get the last cut here. So I'm going to unmute you. Go for it. Holly.
Hi, Professor. Hi, everyone.
Hi.
I had a question regarding the Defense Production Act and why it is. I mean, I don't understand why it is that the president is so hesitant to invoke it under the circumstances, especially in light of the fact that from what I'm hearing in the news, he has, there's a Russian plane coming in. He's ordered PPE that's coming into the country, but he refuses to invoke the Defense Production Act. And I'm confused. I don't know why. Can you kind of provide some insight as to why you think he may be kind of stalling?
I'm going to take my best crack at it. I'm going to put you on here. Great question. I'm glad, and this is a really good one to end on, Defense Production Act, which is something that we haven't talked about yet. So the DPA is a statutory authority that the president has to order private companies to provide services or equipment in a crisis. President Trump early on sort of threatened activating the DPA. He later then did activate it against General Motors. The question is, and the really, I think, really good and hard question is, why hasn't he activated it more broadly to force companies to produce protective gear and other kinds of equipment that might be useful in combating coronavirus and COVID-19? I gotta say, I really just don't know. This is, there's nothing that would compel the president to do this, and yet the president has the clear authority to do it. President Trump has exercised the DPA power in other contexts during his presidency that I think are not only arguably, I think quite clearly less severe than this one. And so why isn't there a more aggressive activation of the DPA from the White House? I really don't know what's going on, other than to take some of the stuff that we hear from the White House seriously about their reluctance to activate the DPA. That what President Trump says is things like that's not what America is all about. We're a free market system, and so we're not going to do a government takeover of businesses. But it's a little disingenuous because the DPA is quite clearly not a government takeover of private businesses. And as I said, this president has activated DPA authority in other contexts that are, I think, quite clearly less severe and threatening than coronavirus and COVID-19. So why not? I don't really know, and I hesitate to venture a guess beyond that. I know there are a ton of really good questions out there, and I'll make a deal with everybody still on the line. We still amazingly have 90 people, even after the 1 o'clock cutoff. If you all would like to do this again, I would be thrilled to do it again. If we have the support from the administration and tech, which again, I thank everybody who was involved in this. It really was a team effort. So thank you, especially to Michael, to Jody, Dean Dickerson. You're all just the best. I thank you from the bottom of my heart. What a terrific idea to do this, and a terrific program. I hope it was helpful to everybody. But you know what, everybody, listen, more than anything else, I just hope you please stay safe and healthy. I'm really thinking about you all. I wish I could be with you in person, but I love the interactive feature here, and I'm so glad that we were able to set this up. If you have additional questions, feel free to drop me a note. I'd love to hear from you, and use that as an excuse just to say hi, and we can answer questions that way as well. All right, so I'm going to